You know what nobody wants to say? June at the Supreme Court is more consequential than any session of Congress this decade. The 14th Amendment, the Second Amendment, Title IX, presidential firing power, all of it dropping before summer recess.
CBS News has been tracking the term's remaining cases, and the scope is genuinely striking. Birthright citizenship, transgender athlete bans, gun rights for drug users, the independence of federal agencies.
23 cases, all of it due before these 9 people pack up and go on vacation.
And the term was already a blockbuster before today. The court struck down Trump's tariffs, weakened the Voting Rights Act. This is the encore.
And here's what gets me. The rulings still on the table aren't procedural housekeeping. They're the ones that reshape the country. Trump versus Barbara on birthright citizenship, the trans athlete bans out of West Virginia and Idaho, a Second Amendment case the NRA and the ACLU somehow ended up on the same side of.
That last one deserves more than a sentence.
Oh, it's getting a whole segment, trust me.
And on the executive power side, Trump versus Slaughter goes after a 1935 precedent that's protected independent agency heads from getting fired by the president. If the court guts it, that touches the FTC, the NLRB, the FCC.
And possibly the Fed, which is where it gets genuinely interesting.
That's the fault line we'll walk through.
Plus, and I'm not going to oversell this, we close with a mock nickname draft for all 9 justices based on their oral argument performances this term.
You'll oversell it.
Probably. First up, the 14th Amendment and what 128 years of precedent may or may not survive. Before we dive in, a quick reminder. We love hearing from you. If you have questions or topics you'd like us to cover, head to the link in the description and submit your question. We read every single one.
All right, here's what's going on right now, and I want you to listen closely. 23 cases. That's what's sitting on the Supreme Court's docket before these justices pack up for the summer. 23, and they've got to get through all of them by late June, maybe early July.
And these aren't routine cases. CBS News ran through the list. Birthright citizenship, transgender athlete bans, gun rights, presidential firing power, the 14th Amendment, the Second Amendment, Title IX, all in the same month.
Just a light docket, nothing major. NPR confirmed 23 cases left out of 58 argued this term. The court already took down Trump's tariffs, already weakened the Voting Rights Act, and they're not done.
That's the part people aren't fully tracking. The blockbusters that already landed, those are the warm-up.
Right, and here's what gets me. This isn't a normal end-of-term sprint. Every major case left has Trump's fingerprints on it. Every single one. You've got the president's ability to fire Fed governors. You've got his executive order rewriting birthright citizenship. You've got state trans athlete bans his administration is backing.
U.S. News pointed out several of these decisions could upend election processes heading into the midterms. So the stakes aren't just constitutional, they're immediate.
And whatever comes down, stays down. That's the thing about Supreme Court rulings. There's no press conference, no walk back, no, the president didn't mean it that way.
Right.
5 votes, and it's settled law.
Which is why conservatives either bank a generational win in the next few weeks, or they watch this court punt on the things that matter most.
Yeah, and punting has consequences too. The culture war conversation heading into summer gets rewritten either way.
Either way, the country gets an answer.
So here's the question I want you sitting with. When the court takes up a century-old understanding of who gets to be an American, how far are 5 justices willing to go?
All right, birthright citizenship. Executive Order 14160, Day 1 of Trump's second term. The order says children born here to parents who are in the country illegally or on temporary visas no longer get automatic citizenship. Every court that's seen it has blocked it, every single one.
And the Library of Congress analysis makes clear why. The government is fighting a 128-year-old Supreme Court precedent, United States versus Wong Kim Ark, 1898. Born in San Francisco to Chinese parents who couldn't naturalize, court said he was a citizen, full stop.
That case is the wall. And you know what nobody wants to say out loud? The government has to convince 5 justices to read Wong Kim Ark differently than nearly every court has for over a century. That's the ask.
The hinge is 4 words, subject to the jurisdiction thereof. The government's argument is that parental immigration status determines whether a child falls under that phrase. It's a narrow, originalist reading, but the oral argument signals did not go their way.
Trump flew up and sat in that courtroom on April 1st for over an hour.
Wow.
April Fool's Day. I'm not editorializing, that's just the date.
The skepticism from the justices, including Trump appointees, was pretty hard to miss. A ruling is expected by late June or early July.
Here's my read. If the court upholds this order, even on narrow statutory grounds, it's the biggest immigration ruling in a century. 250,000 U.S.-born children a year are affected by this question.
Now, here's where I push back, not on the policy debate, but on the mechanism. An executive order rewriting a constitutional clause is a significant ask. If Congress wants to define subject to the jurisdiction differently, that's a legitimate fight. But 5 justices doing it through an EO feels like a shortcut that creates its own problems.
I hear that. The legal path is messy, and the ruling hasn't dropped yet. We're waiting. But the 14th Amendment is the thread running through this whole term. Citizenship clause here, equal protection clause next, because the trans athlete cases rest on that same amendment.
Same amendment, different battleground. These 2 cases, West Virginia versus BPJ and Little versus Heckox, hit the court January 13th. Trans athlete bans. And SCOTUS blog reported the conservative majority looked ready to uphold them.
That reading is pretty well supported. The question at oral arguments wasn't really whether the bans survive, it's how broadly the court writes the ruling.
And that is where I want my victory lap, Reagan. Nearly 30 states have these laws on the books. A clean ruling validates all of them at once.
Okay, hold on, because the Idaho case has a wrinkle worth flagging. Lindsay Heckox actually tried to voluntarily dismiss her case. The district court said no, but that mootness question doesn't just disappear.
So the court might sidestep Idaho entirely?
Possibly. West Virginia may be the only ruling we actually get, which matters because the 2 laws are written differently.
They couldn't just let us have the clean sweep.
Rush.
I know, the law is complicated. Fine.
But here's what conservatives should actually want precision on. Both cases hinge on equal protection under the 14th, the same clause we just finished unpacking on birthright. A sweeping ruling that defines sex categorically could generate precedent that travels well beyond athletics.
You're saying win the battle, lose the
broader equal protection war, potentially, yes. The justices who seemed skeptical of a sweeping decision weren't all on the left. Even Gorsuch questioned where the line is.
Gorsuch?
Right. CBS News flagged this too. The term isn't just about one culture war headline. The structural implications of how the court writes this opinion matter as much as the outcome.
So Reagan says win, but read the fine print.
I'd take the W. I just want to understand what we actually won.
Fair enough. And speaking of coalitions that make 0 sense, wait until you hear who's on the same side in the next case. The NRA, the ACLU, together. I am not making that up.
Okay, weed, guns, and the most unlikely coalition in Washington.
I genuinely love this one.
So here's the setup. A Texas man, Ali Hemani, FBI searches his home. They find a Glock 19, roughly 60 grams of marijuana, and some cocaine.
Wow.
Federal law says drug users can't own guns. Felony charge. The Fifth Circuit throws the whole thing out. Unconstitutional.
And that law, 18 U.S.C. 922 G3, is the same statute that got Hunter Biden convicted.
Same exact law. And you know who's now defending it before the Supreme Court? The Trump DOJ. You cannot make this up.
Seriously.
The NRA hates this law. The ACLU hates this law. And the Trump administration is standing up there arguing to keep it.
To be fair, the Second Amendment principle here is real, separate from the comedy. The ACLU's argument is that unlawful user is so vague it invites discriminatory enforcement, and they're right about that.
Oh, I agree. The principle is solid. I just enjoy the image of the NRA and ACLU filing briefs on the same side. That doesn't happen.
According to reporting from The Trace, several justices at oral arguments in March seem skeptical the ban even clears constitutional review, especially for marijuana users.
So the court appears ready to side with Hemani, maybe on narrow grounds. Maybe they rule he wasn't proven dangerous. But the bigger question is how far they go.
Right, because if they strike it down broadly, you're talking about millions of Americans in legal weed states who currently can't own firearms under federal law.
And here's the kicker. Hunter Biden was pardoned before any of this mattered for him. So he skated. The guy who started the conversation walks free, and the court might fix the law anyway.
The legal system doing its job, just slower than the pardon.
Much slower. All right, from one man's Glock to the president's power over an entire bureaucracy. That's a different kind of firepower.
Now from there, presidential power over the bureaucracy. This one doesn't get the headlines, but it might be the most consequential ruling of the entire term.
I'd argue it absolutely is. So the case is Trump versus Slaughter. Trump fired FTC Commissioner Rebecca Slaughter, no cause given, and she sued. The statute says you can only remove an FTC commissioner for inefficiency, neglect of duty, or malfeasance. That protection has been law since 1935.
Humphrey's executor, 91 years old.
91 years, and the court is now being asked to overrule it outright. If it does, the president gains at-will removal power over the FTC, the NLB, the FCC, the alphabet soup of agencies that have operated independently since the New Deal.
Agencies that answer to nobody elected. Nobody voted for the FTC. Nobody chose these commissioners. That's exactly the problem.
Now, here's where I push back slightly. The independence was the point. Congress designed it that way, deliberately, to insulate regulatory decisions from election cycle politics.
Sure, and Franklin Roosevelt didn't like it either. The 1935 court slapped him down. But Roberts at oral argument called Humphrey's executor a dry husk of whatever people used to think it was. That's the Chief Justice.
Yeah, that's not subtle signaling.
Right.
The court signaled in Slaughter it's likely going Trump's way. Then comes the harder case, Trump versus Cook.
The Fed Reserve angle.
Lisa Cook, Fed governor. Trump fired her over mortgage fraud allegations, by the way, via Truth Social. And the court went cold. Conservative justices who were ready to torch Humphreys and Slaughter suddenly got very cautious when the Fed was on the table.
Because the Fed is different. The court has already signaled it sees the Fed as uniquely structured. You break Fed independence, markets don't wait for an appeal.
Exactly. So the court may split the ruling, gut Humphreys for the FTC and the NLB, but carve out the Fed.
Which means we could get one ruling that reshapes 80 years of administrative law and leaves the most consequential question half-answered.
The most consequential case of the term, and half the country has never heard either name in it.
And speaking of names, we've got 9 justices who've been asking questions all term long. I've been taking notes. I have thoughts.
Oh, no.
Oh, yes. We'll get into those next. All right. I've been taking notes all term. 9 justices, every argument, and I've got nicknames for all of them.
This is going to go well.
All right, Roberts first. Chief Justice John Roberts. I'm calling him Serenity now, because he makes that face every time a colleague goes 3 minutes over on a question nobody asked.
SOTUS blog actually described that face. That's real.
It's documented. Next, Clarence Thomas barely speaks during argument. Maybe 7,000 words all term. 7,000. I'm calling him silent but deadly.
Accurate.
Gorsuch. He raised his voice at a veteran appellate attorney this term for mischaracterizing the other side. I'm calling him the referee.
He does have that energy.
Kavanaugh. Chatty, friendly, always checking on the lawyers. Flight attendant. Is there anything else I can get you?
Stop.
Barrett. Sharp, fast, does not wait for you to finish. The guillotine.
That one I'll allow.
Now the liberal side. Sotomayor, Kagan, and Jackson. The three of them spend oral argument trying to minimize losses. They're not winning cases this term. They're negotiating the size of the defeat. I'm calling them, and I'm proud of this, the loss mitigation team.
That's actually not wrong.
Jackson talks the most out of any justice on the bench by a mile, so she's overtime. Sotomayor is the dissent factory. Kagan is the
smart one.
I was going to say the strategist, but
She's the one the other two are waiting on to write the dissent that'll age well. That's not a nickname. That's actually her job.
yeah, that one landed.
You had 8 good ones. I'll take it.
All right, Reagan's taken the wheel, so here's the cheat sheet. The court drops rulings any day between now and the end of June. No announcements in advance. You wake up Thursday morning and it's there, or it isn't. And then, maybe it's early July. U.S. News reported the justices have pushed major rulings into July in recent years.
So what does a conservative win actually look like when these land?
Great question. Let me tell you what it does not look like. It does not look like a 5-word headline that says court upholds birthright citizenship. That tells you nothing. You need to know, did they rule on the merits of the 14th Amendment, or did they just block the executive order on procedural grounds? Those are completely different outcomes with completely different consequences 2 years from now.
That's the honest caveat here, Rush. A narrow ruling, one that dodges the constitutional question, can actually create more legal uncertainty than a clean loss would. If the court punts on birthright citizenship, that fight doesn't end. It just migrates back down to the lower courts and takes another decade to resolve.
Same with the trans athlete cases. If Idaho gets tossed on mootness, which we talked about, West Virginia controls. But how broadly did they write it? Did they touch equal protection, or did they keep it narrow to Title IX? That's the sentence in the ruling that actually matters.
And the Humphreys executor case. If Roberts writes a carve-out for the Fed and torches everything else, the headline will say court expands presidential power, but the real question is where the carve-out ends. That line gets litigated for the next 20 years.
So here's what I want you to do. When these rulings drop, skip the chyron. Find the actual holding. Ask, did the majority rule on the constitutional question, or did they find a narrower exit? That one sentence tells you everything.
Read past page 1.
Read past page 1. That's it. The court doesn't owe you a clean answer, but you're owed the real one. Go find it. All right, that's the show. 23 cases, 4 constitutional battlegrounds, and 1 very uncomfortable nickname draft.
For the record, the nickname draft was entirely Rush's idea.
Guilty. Look, the bottom line today is this. The rulings dropping out of this court in the next few weeks aren't abstract. They land on real people, real policy, and real elections.
That's the frame I'd carry out of this episode. Whether it's birthright citizenship, the trans athlete bans, or what happens to independent agency heads, you've got the tools now to read those opinions when they drop. Procedural punt versus constitutional decision. Narrow versus sweeping.
Right.
That distinction matters.
5 votes and it's settled law. That's not dramatic, that's just how it works. So pay attention.
Pay attention and subscribe so you don't miss the episode where we actually have answers.
New episodes every weekday. If you got something out of today, leave us a 5-star review, hit subscribe, tell a friend. Reagan, always a pleasure.
Thanks, Rush. We'll see you next time.